Welcome back to Tort Talk. Today we've got Joe Fantini, Mark, and I, 1 week before MTMP. If you're going to be headed to the conference, make sure you reach out to us. You can message us on Instagram. We'll be at the conference all week. We look forward to meeting you in person. But today we've got 4 torts that we're talking about, and we're starting with Talcum Powder. There was big news this week, a huge $966 million verdict against J&J in a meso case. What are you expecting to see with this litigation as we're about 2 weeks out from the first ovarian cancer trial set to kick off in California?
Huge verdict, like you mentioned, John, coming out of California. It's interesting. That's pretty much the same venue where we have the first Bellwether in the ovarian cancer case kicking off in about 2 weeks. So November 3rd, the first post J&J ovarian talcum powder trial is going to kick off. Expect the trial to last somewhere for about a month, 6 weeks. It doesn't look like we'll have a verdict before Thanksgiving, but plaintiffs have previously got some very favorable verdicts out in that jurisdiction. We have a great jury pool out there. So based upon J&J's previous result a couple weeks ago there, I think they're a little worried about this case. Hopefully it's going to help put some pressure on there to get some sort of global settlement done. I don't think we're going to get a global done before this trial kicks off. So we'll either hear that this case is postponed because there's a settlement, or we'll be talking about a verdict in 6 weeks from now, which if there is one, should be a very large number in favor of plaintiffs.
All right, moving on to the next one, Zantac. Oral arguments in the Second Circuit were held last week. How did it go, and what was this argument about?
Right. So we've been talking a lot here about the Delaware State Court where the Zantac litigation is really focused. We have other cases going on in California State Court, Illinois State Court, but we had a really positive expert ruling in Delaware State Court originally that got overturned on appeal, and that brought some momentum towards some settlements that were announced with some of the defendants. Meanwhile, in the MDL, everybody remembers a couple years ago where the judge excluded all of our experts, said that there was no basis to allow them in. Finally, just last week, we had the oral argument in the Second Circuit where we were arguing in essence that the judge in the MDL overstepped the bounds and acted beyond the role of a gatekeeper, which is the court is supposed to do, and say, hey, whether or not the expert relied on the typical information and studies that are relied upon and used reliable methodology, we were saying that the judge kind of put on the white coat and assumed the role of kind of fact finder and saying, hey, this was accurate, this wasn't. And we were arguing there that the judge went a little bit too far, and that if the judge applied the proper standard, which was that as a gatekeeper, our experts should come in like they have in the other jurisdictions, and then that ultimately could revive tens of thousands of cases, would be one of the greatest comebacks of mass tort history. So we'll see what happens there. But what's really important and interesting, Mark, is this is the same Second Circuit where we're going to be arguing on the Tylenol MDL, where we had those cases dismissed previously. Similar type of argument. Did the judge go too far and acted as a fact finder, evaluating in really detail what the experts said, and ultimately can those Tylenol cases come back? So hundreds of thousands of cases at play between those two litigations. I think we'll have a ruling in both of them in Q1 2026.
Wow, so this is really the place to watch for 2 huge mass torts early next year.
Yeah, the Second Circuit's got a lot of activity and a lot of interest from the plaintiffs' bar and the defense bar in the mass tort world.
Next, we have NEC. We know that the Bellwether trial was dismissed over the summer. I think there's a case management conference coming up either this week or next week. That should set the table for what's happening throughout the rest of the year. Can you tell us whatever it is that you know about that conference?
Right. So we have an upcoming case management conference, and we're pretty much expecting the judge to lay out and identify how the Bellwether process is going to go moving forward here. So we had 2 rounds of cases get worked up pretty far for Bellwether. Both of them ultimately got kicked out and dismissed. So we're trying to come up with a little bit better strategy. The filings overall in the MDL, pretty flat right now. We're sticking around 760 cases. I don't think there's going to be a huge uptick there. There's a lot of activity in state court. We talked about the judge who just entered the census requirements in September. So by the end of this year, we'll really have a good idea on the total number of cases that are going to be in the MDL, the framework for the next Bellwether cases. What I would love to see, and we've seen in other cases, is when there's a bellwether case, there's a provision in the order that says, here's the backup case. So oftentimes the case gets worked up, spent a lot of time and effort by the parties, and then it settles or it gets dismissed on the eve of trial. Then we have to work 3 or 6 more months to get another bellwether case ready and worked up. Well, we've seen a lot in Philadelphia, mass tort program. They're known for teeing up that backup case. Hopefully we can get something similar in NEC so we can keep the pressure on, get some of these cases to 26 and see what really is going to play out in this litigation.
On to the next one, Depo-Provera. We are waiting on the preemption ruling, but while the decision is pending, we have seen a flurry of activity. What's going on?
Yeah, we've seen a huge uptick in filings. We talked 2 or 3 months ago. There was only about 500 cases in the MDL. Right now, we're over 1,200 cases pending. So we've doubled the total number of cases in 2 to 3 months. But a really important and positive ruling just got issued at the end of September by the judge. And there's certain requirements, kind of proof of injury, proof of usage that every plaintiff has to put forward really early in the process here. And we were having trouble, some of the plaintiffs getting records going back 10, 20 years. And ultimately, those cases could be subject to dismissal. But the judge entered this positive ruling, which allows plaintiffs to make certain representations or affirmations that they tried to get the records. There's no record statements or these facilities are closed. So it doesn't shut the door on those claims just because the plaintiff couldn't prove it up in this time period allowed right now, and also in the certain manner that the judge was requiring. So that's a positive development. I'm hearing people are feeling good about what we're going to see about this preemption ruling. Ultimately, that's going to determine whether or not this litigation explodes to 20,000 plus, or we're going to see all the activity in state court. We should have a ruling sometime before Thanksgiving.
It's interesting to see all these developments across these case types, as well as the ones we haven't talked about today, as we readjust our power rankings. If you haven't seen last week's episode, we went through the top 10 mass torts for you to pay attention to, and we'll be redoing those power rankings on a regular basis. As we head into Mass Torts Made Perfect next week, I'm sure there's going to be a flurry of activity and discussions, and you will come out of that conference with a bunch of information for our audience. Again, make sure you meet with us at MTMP. We'll be around. Message us on LinkedIn, message us on Instagram, and we look forward to seeing everybody there. Have a fantastic trip out to Vegas, and we will see you next week on Tort Talks.
Thanks, Joe.